On June 13, 1971, the New York Times released the first in a series of articles containing excerpts from an illegally leaked U.S. government study. The study contained highly classified information on the Vietnam War and became known as the Pentagon Papers. It showed the true extent of American involvement in the Vietnam War that had been kept from the public during the Truman, Eisenhower, Kennedy, Johnson, and Nixon administrations.
President Kennedy adopted a policy of broad commitment to the war in Vietnam, even though the American people had been told U.S. involvement would be very limited. Then, President Lyndon B. Johnson waged military operations against North Vietnam. He began planning war in 1964, a full year before the depth of U.S. involvement was revealed to the public.
The papers were illegally leaked to the New York Times by Daniel Ellsberg, a key researcher in the study. He began the research of the study with the belief that the Vietnam War was important to uphold the government's values and worth the time and effort he was given. However, by the time he decided to leak the study, he had lost all hope that the United States could ever win the Vietnam War. In response to the release of the articles, the U.S. government obtained a court order that allowed them to prevent the New York Times from publishing more of the classified document. Daniel Ellsberg then leaked the Pentagon Papers to the Washington Post as well, who proceeded to publish articles containing parts of the classified document, just as the New York Times had done. The government attempted to obtain another court order to prevent the Washington Post from continuing to spread national secrets, but they were denied. Unwilling to back down, the government appealed the case to the Supreme Court. The Washington Post versus United States case was brought before the Supreme Court at the same time that the New York Times case was. The core of the government's argument within the case hinged on convincing the justices that the release of the Pentagon Papers would cause grave and immediate danger to national security. This required the Solicitor General, Erwin Griswold, to submit a brief that would remain unseen by the public because it contained details directly from the classified Pentagon Papers that so many were trying to keep secret. It detailed several segments of the study that could easily threaten national security, according to the Solicitor General. The Pentagon Papers contained information on the negotiations between the U.S. and other countries.
The materials in these 4 volumes include derogatory comments about the perfidiousness of specific persons involved and statements which might be offensive to nations or governments.
The study also contained specific references to the names and activities of CIA agents still active in Southeast Asia, which could, according to Griswold, cause danger to United States assets and their people. The other extensive military information in the Pentagon Papers could also cause danger to U.S. national security by giving the Soviets or some other hostile foreign entity insight into the inner workings of the U.S. intelligence and military assets. Some of the information within the study was also given to the U.S. by other countries with the understanding that the U.S. would keep that information private. The disclosure of the information of our allies always has the potential to cause problems. It turned out to be less of a constitutional question on whether or not the First Amendment is legitimate, but when the First Amendment does not apply to the press in terms of prior restraint. According to Cornell Law School, prior restraint is government action that prohibits speech or other expression before it can take place. If there were legislation in place that prevented the Pentagon Papers from being published, prior restraint would have been legal. However, there was not, so if the government could not convince the justices that the information released would cause extreme danger to national security, the First Amendment would still apply to the situation, allowing the newspapers to publish whatever they wanted. The New York Times argument centered around questioning whether or not prior restraint was really legal in this situation. They cited previous cases where, instead of prior restraint, criminal charges were pressed. It was emphasized that no current legislation prevented the newspapers from publishing the Pentagon Papers, so the government had no grounds to do so.
We have surveyed all statutory provisions which might, by their terms, prohibit the dissemination, to use the broadest term, of sensitive government information. The only statutory provision which is not, on its face, conclusively inapplicable in this case is 18 U.S.C. Section 793E.
And, of course, the brief continues on to explain why various sections could never apply to this particular case. In the U.S. versus Washington Post case, the Washington Post was actually allowed to continue publishing the Pentagon paper excerpts in their article. It was the U.S. government that appealed the case to the Supreme Court. On the basis of this, the Washington Post stated their first argument.
The findings of the district court must be sustained unless they are shown to be clearly erroneous.
William Glendon, the Washington Post attorney, centers this argument around the government's lack of energy and material in showing the need for another trial from a higher court, but he does acknowledge that this case will be important for the future cases. In other words, it is justified that it is in the Supreme Court. The Washington Post brief also emphasizes the government's inability to prove an immediate and grave threat to national security. The Washington Post argument also mentions nuances about the classification of documents. For example, although the document is classified, the newspaper, being in no way affiliated with the government, does not have to uphold the classified nature of the Pentagon Papers. The soul of this particular case was freedom of the press in accordance with the First Amendment and when the First Amendment does or does not apply. For this situation, the justices voted to allow the newspapers to publish articles concerning pages from the Vietnam Study or the Pentagon Papers. They believed that the government had a responsibility to show the court that the information within the Vietnam Study could truly harm national security immediately and horribly. But the government did not, according to the justices, prove that. The vote was 6-3 in favor of the newspapers. The New York Times versus U.S. case is regarded as a landmark for the prevention of prior restraint. It is also very important in freedom of the press and the First Amendment. It truly shows how important the freedom of the press is to the U.S., both historically and currently. It defined the role of newspapers and journalists as not just the bringers of scandals, but also one of the many entities that keep the government in check and responsible for their actions. Daniel Ellsberg himself set a precedent by leaking the Vietnam Study on such a large scale, and his precedent has been followed by a couple others over the years, most notably Edward Snowden and Chelsea Manning.
To me, so self-evident that this was worthwhile when, at the moment, when I came to it, that I hoped that my example would make many other people realize, oh, I can do that, and that's the right thing to do. It didn't happen until Chelsea Manning. And then 3 years later, we had Snowden. It's basically not easy to find others, the three, who've done that on a large scale in 40 years.